For the Ordinance 2022, Ordinance 2025 gives you the widest scope and introduces the provision of a mandatory referral of all the issues and all the cases to who is also qualified, who is certified, and who facilitates the negotiation between the parties and who is a very neutral person. And by the negotiation, the parties arrive at a mutually agreeable solution and an agreement which is enforceable in law. And we also saw the difference, the comparison between a Legal Aid Act 2000 and the provisions of Legal Aid Ordinance 2025. I just want to touch upon only few issues. Where does the tension start? It starts with the difference between two parties, either be it a family dispute or a community dispute or a commercial dispute or an international dispute or the border dispute within neighboring countries. It starts with a difference of opinion, and if the difference of opinion is not addressed, it becomes a disagreement. A disagreement with the parties, which is further escalated into a problem. When it is escalated into problem, these are the phases where the mediation should take place, where the parties should be willing to subject themselves to a mediation, having a neutral mediator, or if they are confident among themselves, they should have negotiation between themselves and to arrive at a solution. If there is no solution, the problem is escalated into a dispute where a third party intervention is mandatory, and this third party intervention, as per the area, we bring in a neutral party who doesn't take positions, who doesn't take sides, but he allows you in a structured manner to negotiate and to arrive at fact-finding issues, fact-finding crux of the problem, to have a mutual agreeable solution. And if even the mediation fails, then it goes into a trial, which is a conflict, and we will not be discussing about violence and war, which is reserved for some other presentation. So this is the genesis or the origin of how the differences is escalated into a conflict, how mediation comes into play, and if mediation fails, how it's translated into a trial. Having said that, how do we go about it? The section 12 very clearly says a case is defined by the one which is filed or yet to be filed, or a pending case in any court of law in Bangladesh. So the cases could be out of difference, the cases could be out of disagreement. The case, in a typical family case, you talk about the differences between a husband and a wife. In a commercial contract or a rental agreement of property, you talk about the disagreement between two parties, and then the problem arises. And this is the right time, or this is the right process where the mediation should begin. And if it is only a difference between a wife and a husband in a family law, or in a family dispute, or in a rental dispute or property dispute, where two parties have a difference, they can negotiate among themselves and arrive at a solution, which can be mutually accepted by both the parties. If they do not arrive at a solution, or if they do not have the distance ironed out or sorted out, then it becomes a disagreement where we need a third party to facilitate the parties, and this third party facilitation is described in section 12 of the Ordinance 2025, how and which are the areas that court can refer to mediation. So the judges have conferred authority and power to refer certain matters to mediation, or the legal aid authority to conduct mediation. So that's another disagreement point. And when there is a problem which occurs, and again it's going to be a third party neutral party, which is a third party neutral mediator or a conciliator, who is going to discuss who's going to allow you to discuss and arrive at a solution. If the solution is arrived against Section 12 of the Ordinance Act gives you a fundamental right to enforce the agreement as an order, which is equal to an order. So therefore, the negotiation, the mediation and conciliation are on a controlled basis where you do not have something imposed on you. However, there is a conflict which is not solved or which is not being addressed at the mediation level, especially in arbitration. And arbitration is more like an imposition of someone on top of you, though he is going to be a neutral arbitrator. He is not going to allow you to facilitate the discussion, but he is going to ask you what is the fact of the case and what is the fact of the matter and what is the fact of the law, and then accordingly adjudicate which party is going to get what and which party is going to be the winner or which party is going to be which party is going to lose. So therefore, quickly I can give you a synopsis. An arbitrative dispute resolution spectrum is mediation, conciliation, neutral fact finder, adjudication, and a hybrid mediation, arbitration, where from informal, private, confidential process, it goes into a formal and public process, and a consensual process goes into an adjudication process. And the parties decide the outcome in the mediation and conciliation and neutral fact finding, whereas the neutral decides the outcome. Parties retain power for the process and parties do not retain power for the process, which is aptly described in section 12 of the Ordinance 2025. So therefore, the Legal Aid 2000 Act and the provisions which is envisaged in section 12 of the Ordinance 2025 gives you an ample of opportunities for mediation. I think the ordinance will be an eye-opener for all the lawyers and also the parties to arrive at a mutual agreeable solution and to regain the control over the process. Thank you very much.